Hello, political scientists. Welcome to the next part. We are on to relationships between different bodies and institutions in government, different branches of the UK government. That's the official title. It used to be called just simply the judiciary. I thought I could say it, but I couldn't. Judiciary. There we go. And we'll be talking about the judiciary. I really struggle with that word. First and foremost, because that makes sense. It also used to be part of the course that we talked about the relationship between the UK and the EU. But I guess that's less relevant these days, given that we've officially left as of, well, the beginning of this year. So, we're into a whole new era. A lot of what the textbook covers, therefore, is no longer applicable. We'll still cover it. We'll still do it. It could turn up in an exam, but I think it's far more likely that they'll ask about our current relationship with the European Union rather than our old relationship with the European Union. So we will truncate that somewhat. What are we going to do today? Well, I'm going to start with, I'll start with checks and balances. If you remember, there was a theory about the separation of powers. When we first started the Unit 2, Paper 2, I made you fill in a massive A3 sheet covered in diagrams, one of which, well, you'll see. We're going to talk about relationships between branches, and in order to do that, we need to know what the branches are. Recognise this? Oh yes, it's the overlapping branches of the UK political system. There are 3 branches. The bottom circle I tend to title the judiciary, the one on the left I tend to title the legislature, and the one on the right I tend to title the executive. Why that way round? I don't know. I just do. You can do them any way you like. You'll notice how I've not labelled any of those circles. However, I will probably keep the judiciary toward the bottom for what I'm... Anyway, the legislature, what's that? It's the House of Commons, the House of Lords. They pass the laws. They make the system by which we live. The executive, well, they're the PM and cabinet, and we've just been doing those just quite recently in previous videos, so you should be fairly up on that, about the role of the PM, about the role of cabinet, whether or not the PM is presidential, whether or not we have cabinet government since 2010. It also includes the civil service, but you'll be glad to know we haven't gone into too much depth on that. I did at university, but that's more of a university topic. The judiciary are the courts, and in particular, you'll notice in the background, the Supreme Court. Supreme Court! I like to think that that's like when it's mixed with cream, and then it's sort of got a light sort of swirl along the top, so it's all black and gold, and then you swirl around a bit of cream on top, and that makes it a supreme, because that's the kind of cooking sauce called. And also the EU, which I briefly mentioned, and we're going to be talking about where does parliamentary sovereignty lie? When's sovereignty? And here I have parliamentary sovereignty over the whole darn diagram, because it lies somewhere within there, but where in there? Which bits are sovereign and which bits are not sovereign? They can't all be it. As we previously discussed, that doesn't make any sense. There has to be some form of sharing. And to help us with that, we have the Queen in Parliament. Now, I know my circle is bigger than the gap between the circles, so sue me. I thought it looked nice. So the Queen in Parliament, the Quimp, is where sovereignty officially lies. But there's no such thing as the Quimp. It doesn't have a physical representation. Rather, it does have a representation. It's the mace in Parliament. But beyond that, there's no body that holds that sovereignty. The Queen herself does not hold that sovereignty. If Liz, for that's how I refer to our Queen, were to commit a crime, she would be tried by the Crown in court. That sovereignty, therefore, does not lie in her person, but in her title, I suppose. And it's not really her title either. And thus, where is it? Do you see what I mean? It doesn't really have a place. So what you can do is you can extend the concept to cover all bits of Parliament, and I guess the judiciary too. Now, this one I maybe should have done an oval rather than a circle, but it covers Parliament, the House of Commons, House of Lords, and the judiciary, you'll note, are on the cusp. They're on the edge, for reasons I will get to. Sovereignty, if you remember, is the power to make decisions, the power to make other people do as you wish, the authority and legitimacy to make your power work. That is sovereignty. Everyone starts out sovereign in the state of nature, but then one gives up sovereignty to various bits of government. So you don't need to worry about individuals, you don't need to worry about us or that particular theoretical chestnut. We're just talking about how sovereignty is actually distributed across the UK system, which over the last year and a bit has been incredibly important in terms of what government has tried to do, and with Brexit. Apparently, a lot of people voted for Brexit in order to retain their parliamentary sovereignty, little knowing what that means. And also, loads of people have started trying to use Magna Carta to not close businesses during the most recent lockdown, which seems to me counterproductive and also stupid. That's not what Magna Carta is. But hey-ho, people believe in popular sovereignty, and they don't know what they mean by that. It's a lovely term. I'm going to try and explain it. Not today, necessarily. We'll see how we go. Now, it used to be, and this is where I bring in the EU, that the sovereignty exercised by the Queen in Parliament, part of it was transferred through the EU and the ratification of the Treaty of Rome of 1957, to which the UK became a signatory in 1975, when we joined the EU proper. It used to be that some of our sovereignty passed through to the European Courts of Justice. The European Courts of Justice, through the Treaty of Rome, had power to decide legal cases and became the highest court of appeal anywhere in the European Union. As a consequence, then the EEC. As a consequence, some UK sovereignty to make our own decisions was passed to the body of EU. Now, the European Court of Justice tended not to intervene in UK affairs. It tended not to get that far. And the judiciary in the UK tended to take their lead from European law. And after the Factortame case, which I will be mentioning later, there's only that one example, they pretty much showed their teeth and said that they would apply European law, meaning that very few cases in the UK ever got to the European Court of Justice. They didn't need to, because the UK judiciary already carried out the European Court of Justice's rule of law, meaning that loaned out sovereignty to the EU came straight back via the judiciary, who then exercised that extra bit of, I suppose, sovereignty. But of course, we're out of the EU now. So where does the judiciary lie? They've got a taste for exercising matters of sovereignty. So what's going to happen? And the answer is, we don't know yet. But we can have a broad guess. Oh no, one of my circles has remained in. That's going to annoy me. No matter, loads of things go over the top of it. We'll just have to deal with it because I'm not recording this again. I'm 7 minutes in. Third recording. It seems like third time is the charm. You don't have to worry about that. So what is the Supreme Court? Well, it was established in 2009 by the Constitutional Reform Act of 2005. It took 4 years to set this thing up. It replaced the Law Lords as the highest court of appeal in the United Kingdom. Now, the Law Lords used to sit in the House of Lords, they still kind of do, and the House of Lords itself, the Old Bailey, became the highest court of appeal. You could actually hear court cases there, leading to a number of overlaps between the judiciary and the legislature, and also the executive. Weird structure that we had going on, and you had the Lord Chancellor who ultimately took responsibility for those things. So there used to be a lot more overlap than there currently is. As part of the then New Labour government's attempt to extricate and to fix the UK Constitution, they separated out the judiciary into the Supreme Court. And that was set up in 2009, just before the coalition government came to power. It has not been rescinded, though the Telegraph did call for Boris Johnson to deal with the constitutional problem of the Supreme Court early 2020. Gee, I wonder why. And I'll come on to that in a moment. So they replaced the Law Lords. They are the top of the judicial system. Everything in the judicial system ends at this chamber. It goes no further. And since we've left the EU, it cannot go to the European Court of Justice. Indeed, one of the sticking points of the EU withdrawal bill was the role of the European Court of Justice over trade deals, for example. Should that be an ECJ decision, or should that be a UK Supreme Court decision? The government initially wanted it to be the preserve of the UK Supreme Court. But after a series of decisions in 2017, 2018 and 2019, Boris Johnson's government decided to hand over jurisdiction of trade deals under the EU agreement we've reached. It's a bridging agreement, it'll last a number of years, to the ECJ, which seems an interesting abdication of sovereignty. I wonder why that is. So that's the top of the tree. The bottom of the tree, by the way, are magistrates' courts. They're run over by, magistrates. Then there's the Crown Court. They try criminal cases. Then there's the High Court. They're next up from the Crown Court. Then there's the Court of Appeal. That's the next up. If you disagree with the decision made by either the High Court, the Crown Court, or the Magistrates' Court, you go to that one. And then the Court of Appeal can pass things on to the Supreme Court. And I still, in my head, imagine a very rich chicken sort of broth with a bit of black and gold in there and cream. It's sticking in my head. I don't care if it's not sticking in yours. One interesting corollary, which isn't actually part of the course, but I learned at university, and I've said before, I'm keen to prepare you for that, is the 1985 Prosecution of Offences Act, which hasn't changed. This act essentially made the police accountable to Parliament. The police services in this country are not accountable to judges, they are not accountable to courts, they are accountable to Parliament. That means that Parliament gets to decide what the police do and whether or not they follow the laws as interpreted by the judiciary. And that's interesting. So when people say the police and the courts, they are in fact including two different branches of government. They're including Parliament and they're including the judiciary. So courts are the judiciary, police are not. And that's an important distinction. I don't know when it'll turn up in an exam, given that it's not on the specification, but it's an important thing to know, and so I'll tell you it. My hair is a mess. So, it's getting far too long. The next thing I need to talk about is what a precedent is. We've mentioned precedents before in class when we've been in school. Now, a precedent is a judgment that sets a standard, and this tells us about the role of the Supreme Court. Their role is to interpret the laws and make sure they're actually enforceable. They decide what the word of law means. Or put another way, senior judges interpret the laws they are given. Because sometimes reality doesn't fit into nice, neat boxes, and you need to judge. Well, it's there in the name, isn't it? You need to judge what the law actually means in a real life situation. So, for example, laws against speeding, you are breaking the law whenever you speed, but you have to be caught. What then about speed cameras? Many people believe that because the speedometer on a car is plus or minus 10% to the actual speed you are doing, therefore you have plus or minus 10% sort of wiggle room when it comes to speeding when caught by speed cameras. A judicial precedent was set, there's no law saying that you can't do that, a judicial precedent was set saying that no, the speed cameras are calibrated, and unless you can prove that their calibration is incorrect, and that falls on you, the complainant, not on the people bringing the prosecution. Unless you can prove that they are wrong, they are taken as your speed. It does not matter what your speedometer said at the time. It just doesn't matter. It's irrelevant. The law does not care. Now, the law itself doesn't state that. It was a precedent set in a number of cases by a number of judges. And as a consequence, that's now part of the law. So I am sorry. Whatever your speedo says, if you're caught speeding, you are thus speeding. That's the way it works. And ignorance of the law is also not a defence. If you don't know there's a law against it, well, tough. And that too is a precedent. It was not passed by Parliament. This is the basis of common law, and it's why slavery never existed in UK law. If you remember, it disappeared in a puff of logic. And that was a precedent. It was an agreement reached in a court of law. No act of Parliament set that standard. So precedents can be incredibly important in understanding the laws, the acts passed by Parliament. The Supreme Court are the final court of appeal. If everything else has failed and you go to the Supreme Court, their decision is final. There is nowhere else you may go. And since 2020, you can't go to the ECJ to review the Supreme Court decisions. Nor can the government, by the way. So what is it? Well, it's relatively new in that it was only set up in 2005 and only took office in 2009. So it's not been around a terribly long time. Indeed, it's been around just over 11 years. So keep that in mind when we're discussing it. When we talk about other institutions in government, we're talking about much longer lived institutions. This court is younger than many of the prime ministers we're looking at, for example. And that means it's a very, very interesting beast and an ever-changing one. When I first started teaching, this didn't exist. When I last taught politics, it wasn't fully set up yet. It had literally just come into being in 2009. So it's an interesting one, is my point. There are 12 justices, and they are led by a president. Now, the recent president in the textbook is Lady Hale. She's there with her spider brooch. However, she resigned on the 10th of January 2021. And since then, it's been run by Lord Reed, who is now the Lord Justice Reed. And he's now the president of the Supreme Court. Now, he's an interesting character too, and the story of how he got to where he was isn't also interesting. I say 2021, it's 2020, isn't it? My apologies. It was in 2020 the changeover occurred. As of the highest court of appeal for, well, the country, what does that mean? Well, it means for things like judicial review. If you disagree with a government decision and you think that it goes beyond the powers that government have, it is ultra vires, Latin for beyond their powers, then you take it to judicial review and you get the judges to check. And their job is to make sure constitutionally that the government has passed a law that they're able to pass. Now, what sorts of things can be ultra vires? Well, one of the interesting examples is the factortame judgment, which I'll come back to later. But also, there are things such as, is it right for government to legislate what goes on in a bedroom, for example? And that caused a number of issues when talking about marital rape. Marital rape was only made a crime in 1993. Just saying. On the argument that it was beyond the powers of government to really regulate what went on between adults in a bedroom. The trick was it wasn't consenting adults, and that's where it hung, and that's why it was changed. It's also the highest court of appeal for criminal cases, apart from in Scotland, where the highest court of appeal for criminal cases is not the Supreme Court. Scottish law is separate to the rest of the UK, and that was because of how it was set up in 1601 with the Act of Union. So Scottish law is still separate to this day. It means that Scottish law has a different age of marriage, for example, than the UK. Well, it doesn't have a different age. You can get married from the age of 16 anywhere in the UK, but in Scotland you don't need your parental consent before the age of 18, like you do in the rest of the UK, England, Wales and Northern Ireland. So that's an interesting one. It means that criminal justice in Scotland ends with something called the High Court of the Justiciary, for criminal cases, whereas in the UK, the rest of the UK, it lies with the Supreme Court. However, for civil cases, i.e. You didn't turn up when you said you would, and therefore you were in breach of contract, that is still the highest court of appeal, even in Scotland. So, yeah, it's just criminal law in Scotland in this case, and it's an odd one. What else does it do? It decides jurisdiction. It decides, under the role of devolution, under the agreements of devolution, whether or not a particular issue should be looked at by a devolved government or looked at by the national government. And this came to a fore when we're talking about Brexit. As you can imagine, Scotland did not vote for Brexit, and they argued that they should therefore have some say in how that was organised. And the Supreme Court largely agreed, but did point out that it was the role of the Westminster government, the national government, to negotiate any kind of treaties with the EU, and that Scotland's role could at best be advisory. They had to be consulted, but they didn't have to be listened to. So that's the sort of thing the Supreme Court decides, and you can see why that plays a huge, huge role. Do I have another image to get rid of that one? I don't. Oh, the circle's going to be right in the way. Sorry. How do you get on the Supreme Court? Well, you get on by a selection commission. The selection commission is drawn, it's 5 members, and it's drawn from the most senior judges in the UK. They provide the recommendations to the Justice Secretary for the Supreme Court. The Justice Secretary has one chance to reject one applicant. That's it. They don't have to give a reason. They can ask for extra evidence, but they only get to say no to one nominee. If they do that, all future nominees in that year are passed. So it's a power, certainly, but it's not going to be used terribly often. Once the Justice Secretary approves of the choices, they are passed to the Prime Minister, who then asks the Queen or the monarch to appoint them as justices of the Supreme Court. That's how it works. I don't know how to pause this, so you'll have to bear with me whilst I try. I can't. Oh no, it's all broken. So bear with. I'm afraid you're going to have a circle in the way. I'm appalled. I'm angry, but oh, luckily it goes over the top. So, okay, what does this mean for the Supreme Court? It means the Supreme Court has to be seen as being neutral and independent. But why? Why does it have to be neutral and independent? It looks like I'm ringing those two judges. I'm not. They're not that important. Justices? Judges. Oh, justices, because they're in the Supreme Court. So, first of all, why should it be neutral? Well, neutral means passing decisions based on the law rather than based on political opinion or other things that may affect that opinion. So you cannot be swayed and partial. Partial means one-sided or the other. Neutral is, well, not necessarily in the middle necessarily. It means staying free of any agreements or otherwise. I guess on any kind of graph it would be the mathematical centre, but it's not necessarily the middle of any argument. To be neutral is not to be in the middle of two opposing sides. Rather, it is to be where the law is, which might not be in the middle. A murderer or an attempted murderer and their victim, well, it's not between them that is neutral. Rather, the law quite specifically states you shouldn't try to kill someone. So, unfortunately, in that case, the neutral position would be against the attempted murderer, who may admit that in this particular thought experiment. Do you see my point? Neutral is not the middle. Neutral is not an opinion between two opinions. Neutral is having literally no opinion, but that's supplied by the law. So why do they need to be neutral? Well, hopefully you can see the obviousness. They need to be neutral to be above politics. What you don't want are politicised decisions. And that's interesting, considering the sorts of things that the Supreme Court has been asked to do since 2017 with the Gina Miller case and Brexit. The Supreme Court has been somewhat supercharged. It's the first time it broke into the media in a big, big way. And so they have to be neutral. They cannot be seen to have political affiliations. Furthermore, there's an argument, not an argument, there's a statement that all are equal in the eyes of the law. The law is equally applicable. It does not matter whether you're the richest person in the country or the poorest beggar in the country. If you're up on a charge of rough sleeping, you will be treated the same way before the law. However, it's not always true, is it? Let's be honest. But that's the theory. The laws are supposed to be neutral and applicable to everybody. Now that is in Magna Carta, and it does say that to no one will we withhold, to no one will we buy or sell justice. That's still going, and that is where the Supreme Court neutrality comes in. They've got to be able to monitor and administer justice in a way that is not partial or swayed by monarchs or powerful people. They're also there to prevent political manipulation. Those politicians who are in positions of power using the law to their advantage and using it to get away with stuff that ordinary people can't, or creating laws solely to protect themselves. And not just politicians, but all powerful people. If judges weren't neutral, then they might not do that. They would do things on a partial basis, based on their backgrounds, based on political affiliation. Neutrality also means that they're free from corruption. Because no one can sack them or threaten them or otherwise influence their decisions, they're highly paid as well, and that's deliberate. It means that they cannot be corrupted, and ultimately their decisions can be seen as, well, real and fair. And that's important. Fairness is a hugely important concept, even though it's not actually laid down in law. We have to understand psychologically and sociologically, that fairness is a human quality, and therefore neutrality implies an element of fairness. And so, in an ineffable way, a measurable way, you have to have a neutral judiciary. Secondly, they've got to be independent. They've got to be able to make their decisions without interference and without fear of losing their jobs and without fear or favour, essentially. Why? Well, it avoids political changes. Otherwise, every time a new government came into being, the judiciary would be rightly worried about which government they'd been appointed by and would make decisions based on whoever's in power, which you don't really want because, well, laws are immutable, well, not immutable, but laws are long-lived. You don't want them to change how they do laws based on the opinion of whoever's in power at any given moment. I mean, imagine, Priti Patel could have brought back the death penalty simply by being in favour of it. They've got to maintain the division between the law and societal norms. Just because people change their minds about what is acceptable and what is not, does not necessarily mean that the law has changed. Let's say, for example, it is now acceptable for people to ask to end their lives with dignity if they don't want to live to the end of their life. Just because it's acceptable doesn't mean that it's morally or legally right. The law says everyone should have a chance to live and that you should try and save lives. Now, morally or philosophically, it doesn't matter. The legal duty is to keep people alive. Just because people are okay with people dying doesn't mean you let all old people die, aka Running Man. Aka? Allah, as in the French, not like the God. So the societal norm may be that people are okay to die at a certain age, but the legal stipulation is that that's still not okay. Furthermore, it avoids corrupting influences. If they are totally independent, if they are financially well off, no one can bribe them. If they are removed from society, then it's really difficult to bribe them by other means, through things like sex, for example, or through things like vice. You can't do it. So goes the theory. And this means, if they are fully independent, that the judiciary, and the Supreme Court in particular, can act as a watchdog for politicians and for the political and economic system. They can make certain that things are the way they're supposed to be, that the Constitution, not being written down, remember, is well protected and serves its purpose well. So that's why. Yeah, but are they really? It is in the background, it's still going to be annoying. I am sorry. The first problem is the fact that all the judges and the justices on the Supreme Court are, well, privileged. They just are. The membership is very privileged. Nearly all of them are privately educated. Nearly all of them went to Oxford or Cambridge universities, referred to as Oxbridge. And this means they are drawn from a particular class. That is upper middle or upper class, because they're the people who go through private education, go to Oxbridge, and have that rarefied academic background, which very particularly sort of self-selects, it gatekeeps itself. No one's prevented from going in, but those that get in tend to be a certain type of person with a certain background. Noam Chomsky talked about this, how you can only get into certain institutions and certain jobs if you hold opinions that people there want you to hold. You don't get censored, rather the system selects people who self-censor in a particular way. This traditional wealthy background means that they're going to find, well, generally in favour of their own sort, of their own kind. If they're mainly white middle-class men, like me, then they're going to probably have white middle-class male opinions. Like me, I guess. There's also the issue of gender. In 2019, there were just 3 female justices in the Supreme Court. In 2020, there were 2. We've lost one. Lady Hale has resigned. So, why is that an issue? Well, I'm going to close with this. I'm going to close with Mr. Justice Hayden in 2019 in the Court of Protection in London. This was a case involving a woman who'd been married for 20 years, but a progressively more debilitating learning difficulty meant that she was deteriorating in her ability to make her own decisions. The court heard a case about a court order being sought to basically say she could no longer give her consent to her husband, and therefore to grant a court order preventing him having sex with her because she was unable to give her consent anymore. Remember, it was progressive. It was getting worse. They'd been married for 20 years, sure, but she had previously said no, and the court order argued that maybe she wasn't able to do that anymore and that this could risk rape. Marital rape, remember. Mr. Justice Hayden, being a white, middle-class male, had this to say about the court order. He said, "I cannot think of any more obviously fundamental human right than the right of a man to have sex with his wife, and the right of the state to monitor that. I think he is entitled to have it properly argued." In other words, he wanted a full trial, he wanted depositions from both sides, and he wanted to understand the intricacies of the case. Now, on the face of it, you might say, well, that's entirely neutral, but it's also very male. Let's just revisit the start of his sentence. "I cannot think of any more obviously fundamental human right than the right of a man to have sex with his wife." A man, not a husband, with his wife, not a woman to whom he is married. That's interesting, the distinction there in the words he chooses. And trust me, judges choose their words carefully. And furthermore, remember that thing about marital rape? Just saying. So that's a thing, and that might be down to the fact that he's a male? I don't know. And that could possibly be an issue? Maybe. Make of it what you will. I merely include it as an illustration of a point. You can argue either way, it doesn't really matter. As with most things in politics, at the end of the day, your job is to make the argument, not necessarily to agree or disagree with them. It's to know what the two sides are and then reach a conclusion based on that. I provide you with the evidence and the examples, that's all. So, Mr. Justice Hayden, an interesting character, respected judge though. And you could argue, well, yeah, all right, having a proper argument about this, it's going to set a precedent. It's kind of important. It's up to you, I guess. That is the introduction. Now, I've already gone slightly over 30 minutes. I'm hoping to get this up in the next, well, it's 10:38 as I record this. It should be up relatively quickly. My apologies for the slight delay. And then I'll do another one for this afternoon as soon as I can. Have a lovely rest of your day. Thank you, if you have been, for watching. And I'll see you, well, in the next video. See you around.